Hello to everyone. So we have one last big effort to do for this course. I know you may still have other efforts till the end of this school year. So we are talking about religious freedom and religious clothing today and religious symbols. You remember last week we compared the situation in France and based on the Stasi report, and we also looked at a German case, the North Rhine-Westphalen case, and I think the approach of both legal orders is quite different, and that is also the aim of the course, to show to you that you can solve a certain problem in different ways. Today we'll be traveling to Canada. Are there still any Canadian students left, or they've all already returned home? I had 5 of them yesterday for early exams. No Canadians left. It's a shame, but well. And we will also be looking at 2 decisions handed down by on the international human rights bodies, the European Court of Human Rights and the Human Rights Committee, also on the same problem but with differing outcomes. Now, when we look at Canada, we will see that we already touched upon the multiculturalism as a fundamental value of the Canadian legal order, and linked to multiculturalism is this concept of reasonable accommodation. So I will try to give you an introduction into what reasonable accommodation is, and the Multani case links to that concept as well. It's a concept which also exists in the United States, but the threshold is a bit harder. And I have noticed that more and more, also European legal orders and scholars look at reasonable accommodation, wondering whether it's something which would be interesting for, for European jurisdictions, and also whether maybe we may have it implicitly. I had a PhD student who defended her thesis on reasonable accommodation, what it could mean for the Swiss legal order. We will then look at the French full veil ban and try and compare 2 decisions and have a discussion about how they differ, why, and I'll be curious to get your point of view as well. So if we go to Canada, I think we have now someone from Canada. You're my victim today, because I was asking who can help out with Canada. So what is reasonable accommodation? It's, I said we know it in the United States and in Canada, and it was, I'm referring here to the case in which the Canadian Supreme Court recognized reasonable accommodation. Maybe I will first tell you what the case was about, and that makes it easier to grasp what the court tells us. So it was about an employee who was a member of the Seventh-day Adventists, and who said that based on her religion, she can't work on Saturday. But her employer, I think might have been a retailer shop, was also open on Saturday. And she asked the employer to take into account her religion and to exempt her from working on Saturdays, which was refused. And the Supreme Court looked at it through the concept, we can see the link here, to adverse effect discrimination. Adverse effect discrimination in Switzerland, we would rather talk about indirect discrimination. So the idea would be that we have a generally applicable rule here in the employment context saying, well, every employee has to work on Saturdays, but this rule has a adverse impact, or you could say a disproportionate impact on religious minorities, here on those religions which basically command that you do not work on Saturdays. So I think the idea behind it is also that, and I've mentioned it at another occasion, that the legal order as such is not neutral. It is always, a reflection of culture, of history, and it's not a coincidence that in most Christian legal orders we have Sunday is the day off, but not Saturday. So the idea of reasonable accommodation is to say if generally applicable rules have this disparate impact or adverse effect, we may have to correct it. And we have to correct it by taking reasonable steps to basically, and how do we correct it? To accommodate, to basically make room for religion. And you can also already see that basically it is not an absolute right. You don't have an absolute right to have your religious practices accommodated, but that's inherent in reasonable accommodation. So we have to ask ourselves, what is reasonable? And the court also says basically how we have to proceed. We'll first check, is there a prima facie case of discrimination? So do we have adverse impact? And then it is up to the employer to show that the employer has taken reasonable steps to accommodate. And what is not reasonable is if it causes undue hardships for the employer. So the question often will be in reasonable accommodation cases, is the demand reasonable? Is it going too far? Does it impose undue hardship? In the United States, for a long time, basically, the burden was higher. You had to demonstrate that it was basically only a minimal, I would say, hardship for the employer. But the Supreme Court has, in a relatively recent case now, also basically broadened or made it easier to get reasonable accommodation. Also interesting, you can see here it's in private law, it's in employment law, so it's a concept which came from employment law, but then also can be used in other settings. Think of the school setting as in the Multani case, where you will try and maybe negotiate also accommodations for students' beliefs. It's a concept, I would say, which we can find also, and in Europe, mainly, there's a lot of mention about it when you talk about disability. So with people with disabilities, you also have to take reasonable measures to accommodate their needs. You may know it from a university or a school setting. That could be extra time for a student who is, for example, dyslexic, or students may be allowed to wear headphones to protect them against noise, etc., or pass exams in different stages. Also interesting is that a reasonable accommodation also basically is based on the idea that there should be a dialogue and negotiation between the parties concerned. So it's not just the outcome, have you taken into account what the person wants, but have you also entered into a discussion, tried to find solutions. And maybe sometimes you will settle for something which was not the first choice, maybe not what the person asked, but it's not just a pure rejection. Then here, still the same case. We can also see that the Supreme Court is mindful of the fact that reasonable accommodation cannot be an absolute right. You can see it here. In any society, the rights of one will inevitably come into conflict with the rights of others. It is obvious then that all rights must be limited in the interest of preserving a social structure in which each right may receive protection without undue interference with others. Then maybe a few words, how do we assess undue hardship? So that's all formulated positively, that the accommodation demanded is reasonable. It's a case-by-case analysis. So you have to look at the circumstances of the case. For example, we can think of, let's take a small shop, may not be able to accommodate. If you have 2 employees, you're a retail shop, it may not be possible to say for you as a small business to have 1 employee absent on Saturdays. But if you're a big structure, then it may be easier. So you will look at the financial implications, the resources demanded, also what does the business do? Is it possible for the business? And also, will there be infringements of rights of others? So typically you could think of, I don't know, take the medical sector, a doctor who would say, I don't want to prescribe contraceptives. Maybe that would be more could be more of a problem, because you would say people may also have a right, or women to contraceptives, etc. I don't know if anyone wants to add something to coming from Canada or so? No? And maybe as a justification, so it is a link to discrimination. The idea is to say, well, if we don't accommodate, it is a form of discrimination. You find it explicitly, I mentioned disability before, the Convention on the Rights of People with Disabilities, it says it clearly, the failure or the refusal to accommodate is a form of discrimination. And another value which you can link reasonable accommodation to is integration. So it's a concept, you have different ideas of integration. So here it's more of a multicultural concept of integration, saying we have to, if we take people's rights and freedom seriously, that helps them to integrate into society within reasonable limits. So that has to be made clear. But it's not an assimilationist conception of integration. You hear an assimilationist approach would be more to say to integrate is you do like the majority. You don't come with your special demands, etc. And you will find courts integration, who doesn't want to integrate, is a positive concept. Like neutrality, you might find very different, it can be filled with different meanings. So here it's really you respect difference, and that helps people to integrate. So I already mentioned when I refer here to the procedural component, that is the idea also that you have to negotiate, that there should be a dialogue, and that dialogue might help for the parties to understand each other better, to understand the employer's needs, but also be more sensitive to the employee's needs, for example, if it's the employment settings, and also be more sensitive to religions we simply may not be very familiar with. Generally, these reasonable accommodation demands are basically relevant at the phase of the application of the law. So because you have a generally applicable law, which does not make exceptions for minorities, you have then the need to accommodate and maybe to be more flexible, make exceptions. But you can also, and the Canadian Supreme Court said so, it should also already be factored in the lawmaking process. So ideally, if you make a law, you should think, well, what will be the impact on different groups in society, and already consider that. This has the advantage that if the law already takes this into account, you have less the criticism which people very easily make to say, see, the law doesn't apply to everyone. We have a general rule, you make exceptions, that's not very coherent. So better to think of it at an earlier stage when you design the law, and maybe there already make some exceptions or try and find a wording of the law which will not have a disparate impact on minorities. It is used mainly, most cases for reasonable discrimination are brought as a violation. So if the employee finds I have not been accommodated properly, generally it's within the ground will be to say it's discrimination. Now you may have noticed in the Multani case, it's not a discrimination case. It's a case brought based on freedom, it was brought under freedom of religion, but we will find a reasonable accommodation as being important there as well. Maybe we can already look at that. Did anyone see how reasonable accommodation appeared in that case? How the court took it into account in a freedom of religion case?
Originally, the school board, first of all, allowed him to kind of wear it if it was in a pocket or like sealed up. So it was reasonable accommodation. He could still wear it, but just not visibly or
So what we can see clearly within the proceedings that there have been negotiations with the school. So basically, probably the student first filed a request for a reasonable accommodation, and there were discussions. One solution which was found was he can wear his kirpan, which something which resembles a weapon, but sewn into his clothes. But then that was withdrawn, still considered too dangerous. And you may have seen they discussed different options. The school said, well, come with a plastic thing or something out of wood. He refused, etc. So there have been discussions. There's this procedural aspect of reasonable accommodation. But the final outcome was that the student was not satisfied. He felt his religion was not taken into account. He was moved to a private school. And the case went to the Supreme Court under the heading of violation of freedom of religion. And did you see how the Supreme Court took into account reasonable accommodation? Or what do you think? How would it be possible to take it into account? Think of the general requirements to limit the right. Generally, you have to have a legal framework, which here would be safety regulation of the school. You need to have a legitimate aim, which is not that hard to find. And then you have, in Canada, it would be also, would you have the Oakes test, the proportionality assessment. Can anyone make a link to reasonable accommodation? I've helped you a bit. It has somehow to fit into, I would say, proportionality.
So it's the proportionality also is around like minimum impairment. So this idea of, you know, what is the least interfering that we can do, and is there a way that you can ensure security in the school if that's the claim without infringing on his rights? And so then the Supreme Court looks and says there's never been an incident of violence with the Kirpan. So in hundreds of years of students coming, Sikh students, there's never been a problem. So your reason to infringe on his rights doesn't hold water.
We will go back to the safety issue in the discussion, but basically the argument is if you can make a reasonable accommodation, you don't make it, that results in a disproportionate interference with the right. So failure to accommodate can mean that the restriction of freedom of religion is disproportionate. I think that's how the court makes the link to. I will just give you maybe the passage it refers to. I think I went too far quoting Whirling. I know that. Maybe someone will be faster than me. Minimal. Yes, it's on paragraph 52, where they say, in other words, she could not conceive, quoting another judge, of the possibility of a justification being sufficient for the purpose of Section 1 if reasonable accommodation is possible. So there you have the link. If you can make reasonable accommodation, you don't do so. It's a disproportionate interference. I remember I had interesting discussions with my PhD students. You know, does it matter whether you bring it under freedom of religion or whether you bring it under equality? What do you think? Should it matter? Does it matter? The question was, you know, because I've seen also in Swiss case law, sometimes courts do make this type of reasoning saying, well, we could have made exceptions, it's not such and so on. So in a way, implicitly, I was arguing they do sometimes do something like reasonable accommodation. My PhD student said, yes, but it's not an equality claim. It should be an equality claim and not a freedom of religion claim. And I remember also we had, it was about 2 years back, we had a conference here with a Canadian scholar who was also very critical of this judgment, saying that's a misapplication of reasonable accommodation, that should have been examined under equality. So I was wondering, does it matter? It's a sincere question. What do you think? Does it matter whether we bring it under equality or the freedom of religion also? Any ideas on that? Question which doesn't inspire also.
I don't know, and so like I grew up in the US and my mom is Canadian, so I'm very curious about also those perspectives. But I feel like if it's under freedom of religion, maybe there's somehow something that should be even more protected rather than equality, like there's a certain amount of like the employer or the school should do the best they can, but they're trying to ensure equality between lots of people. Somehow that feels a little more distant to me, but that's a gut read that has nothing to do with law.
Well, I think we all have our gut feelings. My PhD student's gut feeling was it's more protective to bring it under equality. They were saying, well, then you say, you know, you really discriminate someone, that's worse than just saying it's freedom of religion. So I don't know. It was a sincere question. Both can have, sometimes you can have, the equality framework can have the difficulty that you have to choose who you compare it with, etc. So, but no, let's say generally, it's quite an exceptional case, the Multani case, as it was a freedom of religion case and not an equality case, but we can still see how basically reasonable accommodation plays a role there. I was arguing that was more for the Swiss context. Sometimes if you want courts, the case law to evolve, you may have more success by relying on what they do already. And you've always, you know, in proportionality analysis and pushed them a bit further than saying, you should change totally, and, you know, you should now analyze it under non-discrimination, which at least I find Swiss case law not very protective. So generally, we can see reasonable accommodation used for discrimination claims, but it can also, as in Multani, that's what we have here, to assess basically whether interference with a fundamental right is proportionate. Then what I find that's more sociologically interesting, that the reasonable accommodation basically gave rise to a lot of discussion and also tension, but mainly in Quebec. And I'm not a sociologist, but I think maybe Quebec partly is closer to France in its way of looking at things. So this multicultural framework has really triggered quite some restriction. And there was a commission, the Bouchard-Taylor Commission, where you could see the reference there. They had basically the mandate to look at reasonable accommodation and the crisis it was said to have provoked. And the report is interesting. It basically concluded that there was not a problem with reasonable accommodation, but there was a problem of perception of reasonable accommodation. Saying one problem is that in the media, you will always find the most extreme cases. That's why I put the cartoon on there. They always try, you know, the heading, this guy asks for whatever. And basically, the Multani case was one case which was mentioned in the report, which got a lot of media attention. You know, under the headings kind of, students can go to school with daggers and they can now, you know, it's national, it's a security threat. So the perception, the role of the media was mentioned, and also what they said is that you get disproportionate attention to claims brought by so-called foreigners, migrants. So generally people will focus more on demands if it is, for example, a Muslim wanting to be accommodated than if it is an Adventist or so. So the interpretation is to say if it's a minority who has been in Canada for a long time, they are generally well integrated. There are some people who push it a bit far. But with immigrants, it tends to be the opposite. It's to see it's proof that these people don't want to immigrate, to integrate, and then sometimes you find very stereotypical reactions. I remember, I think it's in the report as well, one municipality adopting a code how foreigners have to behave, and it would say things like, in Canada it's forbidden to stone women and to do this and that, and you would be like, you know, the vision really. So interesting report, but it also shows the reasonable accommodation is not something which gets naturally accepted by everyone. No? That can really cause tension, and so it may also depend in which, we have to ask ourselves, in which context would it work, in which context would it not work. And interesting, in the Stasi report, by the way, you find one reference to reasonable accommodation, and I have to say it has nothing to do with it. I mean, the French concept of laïcité certainly is not reasonable accommodation. So this just, if you're interested, I mean, that report, I think is worth reading, obviously, just if you're interested, not part of the exam. Now, when we look at the Multani case, we can look at it from also, first of all, I think it's interesting just from the point of view, what is the scope of freedom of religion? We have talked in previous classes about how do you establish, that something is part of your religious beliefs, and I have told you there can be different approaches, a more objective approach where you try and link it to some group, also saying, look, there are people who will have that interpretation of a religion, and more subjective approaches. How would you qualify the Canadian Supreme Court's approach? We talked about Mrs. Aveda saying as a subjective approach, saying, well, I feel that my Christian religion commands I wear the cross openly. Here it's about wearing the kirpan. I don't think it was a particularly hard case, not as hard as, the Aveda case from that point of view. We talked about Pastafaris as well. Does anyone see what is the criteria to establish whether this is a religious command? Yes.
It says they must show they sincerely believe it, and that it's in good faith and not be fictitious, capricious, or an artifice. And so they say they will provide an evidence, and no one contests this fact that in the Orthodox religion, they sincerely believe in swearing.
So you have this concept of a sincerely held belief. You can see that's more of a subjective concept to say, is it for him really, is that a sincerely held belief? So he understands the religious command as, I have to wear a kirpan, and then they try also to give some guidance. What does it mean, the sincerely held belief? How do you basically define it? And you've also given the elements there. So they will basically require that it's not fictitious. And I think it also has, what is it, capricious, I think. Not fictitious, capricious, or an artifice. Could someone think of examples where you would say this is not a sincerely held belief? How would we go about that? Anyone got ideas or so? Why put down these requirements?
I mean, maybe it's something that could be shown in the actual behavior of the person, of like, if you're trying to claim this right, but in fact you half the time go around with your hair out and don't follow any of the other commandments of this religion, then how can we say that this is a requirement for you? Like maybe there's something in the conduct of the person in question.
So you could say if you're not consistent, and one day you insist and the other day you don't, or whatever, and so I think that could be an element. Certainly, are you somehow coherent, consistent, etc. Becomes more difficult if you have people saying, okay, I respect some commands and others not, because that could be your interpretation of a religion. You may probably, I gave this extreme example for some people saying, for me, smoking dope is a religion. They'd probably say, well, that might be artificial just because you don't want to be caught up by criminal law, if you can't point to anything bigger. Then still, it's a subjective approach, but we can see, I think it's not, these two approaches do partly overlap, because they did look at what does Sikh religion say. So it was still also linked to the practice of Sikhs, the Sikhs having these 7, as they call, I think, the 7 Ks. They have to wear not just the kirpan, it's also their long hair, the turban, etc. So here it was not questioned, it was said, well, he made it clear, and it also, then the interference with his rights, it's still quite important. We can also see it from the fact that in a way, he felt really in a dilemma, saying, either I respect the school's rules and I have to violate the commandments of my religion. So he went, or he was put into a private school. So clearly there was an interference with freedom of religion. Freedom of religion applied because there was this sincerely held belief. And then the question was, the court examined it under Section 1, so the limitation clause wasn't so complicated to find a reason why the school banned the kirpan, safety. But we do have then considerations about what does safety mean. And I think that was already under the illegitimate aim. We have some, I think, important qualifications. What does the court tell us about safety? Can a school in a way ban anything which potentially could be a security threat? If you want to have absolute safety, zero risk, is that possible in a school setting, you would say? What would you need to ban if you want to have absolute safety? Anyone?
Things like pencils or scissors.
So if you wanted absolute safety, I think it was interesting that the court did make some developments of that, saying, well, in a cafeteria you have knives, you have in geometry compasses, think of sports, you have baseball, how do you call them? The bats, okay. You would probably need to scan every student coming in because you could hide weapons somewhere, etc. So they do stress, look, we also have to be realistic and say we are not going for minimal safety. That's not the idea either, but absolute safety is not possible, not feasible. So we're going for a reasonable level of safety. And you can have, unfortunately, accidents in a school setting with school tools. I have a friend who's a teacher, and in her school they had a case of a student. They had manual work, and he took one of the tools and stabbed the kid next to him to the throat. So it was very serious. The child almost died. But again, you know, you will say you still do manual work. You can't rule out or ban everything. So we want a reasonable level of safety. And then the court looked mainly at proportionality. We already heard that there was evidence that is also, if you want to be protective of rights generally, you will try and be quite concrete. You will not say the abstract risk that someday someone could is not good enough. So they basically said, look, we've had Sikhs in Canada now for hundreds of years. Nothing ever happened. Do you remember other arguments brought forward? Could be in favor, against accommodation here.
One thing that feels very Canadian is in paragraph 76, there's the religious tolerance is a very important value in Canadian society. And basically they have this argument of if students say it's unfair that he can bring a knife and I can't bring a knife, then it's like, that's an opportunity for you to explain what the Sikh religion is and what this dagger means, and it's not a symbol of violence. And like everyone is welcome in this classroom, and then we all move on. And so this idea of multiculturalism as one of the fundamental values, and therefore we should allow him to come with his full religious representation to school, like that is very Canadian as like a central value.
That's what I highlighted in the case as well. I think you can see this multiculturalist approach by saying, also when they criticized the school, basically said, this is a weapon. And the court basically says, well, you strip the kirpan of any religious meaning. It's a very negative assessment you are making of a religious symbol. That's not compatible with this idea of a tolerant, multicultural society. And then a standard argument, well, it's really standard, whatever, also when I've seen it a lot in school setting, it's what will the other students say? You know, how can they understand that, I don't know, student X wants to wear a headscarf and they can't, the school ruling said you can't have baseball caps or whatever. What about they can't bring knives and they might want to arm up because this guy is so dangerous with his kirpan. So that is basically create inequality. I think one answer which the Canadian court doesn't insist on too much, but is to say it's not an inequality because precisely you have a disparate impact on the minorities. And second, it makes, in my view, a difference whether you claim I want to wear something for fashion or whether it is because of a religious command. I would say the weight of you might have a fundamental right, the European Court says it's Article 8 of your physical appearance, but that right does not get that much weight as freedom of religion, as the feeling, well, it's a mandatory command of my religion which I have to violate. And as you said, what is the answer by the court is to say, well, do your jobs, educate people, explain it to them. And it's actually, and that has, the accommodation has a lot of weight. And they also basically say, well, you know, if all the rest gets accommodated, be it knives and whatever, and in cafeterias and so on, well, it just shows you just didn't give much weight to the students' freedom of religion. So I think these, you will find on page 334, paragraph 71, where the court is critical of this idea that the kirpan is a symbol of violence. It says, it is also disrespectful to believers in the Sikh religion and does not take into account values based on multiculturalism. And then you have paragraph 76, that they say religious tolerance is a very important value of Canadian society. If some students consider it unfair that the student may wear his kirpan to school, etc., it is incumbent on the school to discharge their obligation to instill in their students this value that is, as I will, the very foundation of our democracy. And it comes back, paragraph 78. So bear it in mind that in Canada you have a provision on multiculturalism. We've seen it in the Keegstra case on hate speech, and that they will give multiculturalism a lot of weight and important value. Also, paragraph 79 is basically, they find that a total prohibition sends students the message that some religious practices do not merit the same protection as others. On the other hand, accommodating and allowing the student to wear his kirpan under certain conditions demonstrates the importance that our society attaches to protecting freedom of religion. So clearly, I think here you have a judgment very much inspired by a multiculturalist framework. Other reasons you find in the case is also, I said they are very concrete. They look at, at evidence. Have there been problems with kirpans? They also distinguish the school settings from, for example, airports and court settings by saying, well, in an airplane, you don't know who turns up. So in a school, you generally know the students. It's more of a community. They took into account the students' behavior, which I think makes a lot of sense as well. If you may have some circumstances where you'd say, well, maybe this student, it would not be a good idea. And also the risk was quite small that someone would steal the kirpan as it was sewn into the clothes. I can see a question.
Yeah, because I think it's not only the court makes this comparison, but the respondents try to make the case that I think the same person tried to wear skipas in an airplane and was denied. And on the basis of this, they tried to deny to wear it in school, or like one of them was this. And then they brought it up, and the safety concerns are not the same in school and the airplane.
Yeah, I took a bit of a shortcut. You're right in saying that it was obviously the school authorities coming up and saying, look, everyone will look for precedents. That's normal, saying, look, we've seen cases where, the people were denied a kirpan. In the court setting also, there were decisions saying, I think you can't come to court with a kirpan, saying that could, if I understood correctly, affect judicial independence also. Which I don't know, does that affect judicial independence? Well, I don't know, but it's certainly not different from a school setting. I mean, that we can agree with. Other comments on this case also? So certainly an interesting example of what does it mean if you take this multiculturalist approach. And we will see that certainly when we move on to the next two cases on the full body veil, that there we will not find as much multiculturalism, I would say, as in this Canadian case. So just as you will be taking, a lot of you, I assume, will be taking the exam, you can be asked to explain what reasonable accommodation means, right? So do try and understand what it means. You have it on the slides. And also discuss, show how it can fit in the Multani case, that it's integrated within the proportionality analysis. And maybe just as we had some early exams already, what always strikes me that a lot of people don't bring their readers. Bring your readers. I mean, you have them for some reason. I mean, obviously, I won't impose it on you, but I think it's a bit of a shame you deprive yourself of the material used. And it's good also, sometimes I can also help you and say, look at this page, what would you, and if you don't have it. So that's a practical hint. I want things to go well for you, right? So let's look at the French full veil ban. It's certainly a topic which has also basically very present in the media. France is not the only country, I think, within Europe which bans the full body veil. We have, I think, Belgium as well, and Switzerland. In Switzerland, it started off with a cantonal initiative in the canton of the Ticino, banning the full body veil. And then an initiative launched on the federal level. So now it's Article 10A of the Swiss Constitution, which basically forbids the full body veil. So we are part of, I don't think there have been any applications yet. Have you seen any also? No, it's, so I suggest maybe we take one case after the other. Let's first look at SAS versus France. Let's maybe just collect some feedback. What did you notice in the case? What have you, anything which you think is relevant, which you might have found interesting, or maybe you approve, you don't approve, and will be later a bit more systematic. Overall impression of the case? I have my own, but well, I want to hear yours. One question, was it obvious for you where the court was going by reading the case? There are some judgments, sometimes you start reading them and you feel quite soon what the outcome will be. Did you get that feeling with SAS that you could say quite soon, I think I know what the court will decide? Or?
No, I feel I only knew the answer until I get the end of the judgment. And I think the dissenting opinion really strikes that characteristic of the judgment, that the court's rationale and argumentation is a bit vague. It's not systematic, and its reasons are somehow vague. I think the reasoning is, well, when addressing the interests that are supposed to justify the prohibition, they don't seem very positive. I mean, there's no such thing as a right to have contact with other people. So I'm uneasy with the judgment.
So you were rather critical on saying, I mean, any other comments on that? Did you also have to wait till the end to know what the court would do? Or anyone felt, well, I knew that earlier or so?
I would agree, because it feels like they said things like having a blanket ban is unjustifiable, and how expressing your cultural identity is essential for democratic society, and they were saying all these things, and then said, oh, but then actually this ban is like justifiable and
I think, this back and forth, that's what I felt as well. I thought it was almost like a slalom, going in one way and then, oof, we go the other way. And I got the impression, but it's an impression, that the court, on the one hand, was not fully at ease with the ban and did try and say, well, we are aware this creates problems, etc. And, you know, some arguments are not relevant and careful. It could create, when you have parliamentary debates on that, it could stigmatize Muslim women. And at the same time, not wanting to go against France and say, but this is very important what you have to do as well. So I'm not sure, I felt I wasn't really sure where this case was going. And also I'm not sure, and we'll discuss it after the break, just about the standard of review, if the court was always consistent. I had the impression at some points the court would say, we have to look at it closely, and then came the margin of appreciation. You go like, well, didn't you before say you want to look at it closely? So I got the impression very much we try to please both sides as much as possible, but maybe, I'm not sure whether they are. The judgment as such is that easy and logical to follow through. But we'll discuss that about after So let's look at SAS versus France. So we were more before the break collecting a bit your impressions, your general feeling. When we look at it more systematically, one question arose was also, which rights apply. You may have seen that the court applied, not surprisingly, Article 9, freedom of religion, together with, at the end, also Article 14. Article 14, the prohibition of discrimination. You always have to link it to some other right in the convention. And then the court also mentioned Article 8, the right to privacy, which here was also used as the right, basically, to choose your appearance. A question which also arose in a case like that is sometimes, have you got to already, is it necessary that you have been fined to be able to file an application with the court, or can you act just because of the law as such? The law gets enacted and you say, well, it's obvious sooner or later I will get fined if I go out. So there the court basically looks at it from the point of view of the interference. I'm just signaling that to you. It's paragraph 110. And generally the court developed this case law. It refers to the Dudgeon case, saying generally you will have to show that the law has been applied to you. Otherwise, you're not a victim. You don't have victim status, and that would mean that it's Article 34 of the Convention. You can't file an application. But there are exceptions, and one exception is what the court calls potential victims. And the court says if you have a criminal law sanction, basically that already impacts your behavior. Because you will say, well, maybe I will just not go out because I will get fined. And you can't, in a way, ask the individual to already provoke a criminal sanction to challenge it. So the court here did accept also victim status. I didn't reproduce the full judgment, and here also said there was interference. I also thought that was a point not treated. It was quite interesting that the applicant said, well, she does sometimes wear the full body veil depending on her spiritual mood, not systematically. I'm not sure whether that was the best argument to make. It was a bit risky in my point of view. It could have been said, well, so it's not so important to you. But it's just flagging as a side thing. Then the question was, if you're under Article 9, you have to show, again, the general limitation clause, or the general conditions. The interference is prescribed by law. There was a law in France, and it was that law which triggered, I would say, the case, that it was sufficiently precise. Then comes the question of the legitimate aim. The court generally, and you will find a lot of cases where the court spends little time on that. Here, what were the different legitimate aims discussed? Some were accepted, some were discarded. Yes.
They found two legitimate aims. There was, well, the government argued two, like, so public safety and then respect for the minimum values of a democratic society. So they found the public safety one wasn't a legitimate aim, I think, but then for the democratic society, that's the one the court found that did have a legitimate aim because it's about social interaction and how the freedom of thought.
So you mentioned two aims which at the end the court accepted and looked at. I think public safety was accepted, but just it's more a question of what does it, can it justify a blanket ban? And I think that's where the court said, well, actually no, because we can understand at airports or security checks, but generally to say that this is a security hazard goes too far. Then we will return to this vivre ensemble, as it is called in French, living together. There were other reasons which France had invoked as well.
There was also something about the submission that it is about the respect for the equality between men and women, which the court rejects or is not convinced by.
What is your point of view on that argument? And you can find it quite regularly, and also you may have seen when you look at the Human Rights Committee case that there were differing perspectives on that. But I think I may have mentioned it last time. I thought it was interesting. For example, in Switzerland, we have these extra parliamentary commissions where the one for question féminine, so more about on gender equality feels, basically all these, the burqa clearly like other, it's basically but it's it's a reflection of a patriarchal society. Women, have to hide away. And then you have other commissions like the one against racism rather saying, no, this has nothing to do with it, or it might be counterproductive. There you do have disagreement. Have you got a take on that? The court basically dismissed gender equality. It didn't consider that this was a legitimate aim pursued.
In a foreign setting, and the problem with that is that you tend to pose judgments that are maybe not what that person, how that person lives their religion through their daily lives. So the problem with assuming that it's gender inequality sometimes prohibits people of their freedom, of their rights within themselves. So
when you limit someone's rights, when you say the exercise of someone's rights in the name of gender equality, how do you call that in philosophical terms? Anyone? It's a general question of philosophy. You protect someone against themselves. And that is called paternalism. There's big debates in, for example, in liberal philosophy, to what extent, when is it legitimate to protect you against yourself? So there can be different views taken. And the European Court does say in one passage that basically it does not accept gender equality because if it's the exercise of a right, it would mean you in a way protect the person against herself. So it's an anti-paternalism argument. But there's interesting cases, for example, assisted suicide, where people will feel, is it my freedom always in any condition to say I've had enough of this life? Or to what extent will you say you have to protect people, against themselves, etc.? What mental capacities have you got to require, that you can exercise such a right? The court also handed down a judgment, sadomasochism. To what extent, can you prohibit such practices when people commit quite significant harm to themselves? So here the court basically says, I have to find the judgment. You could see that gender equality was a lot invoked in the French setting. I mean, the different resolutions and so on by Parliament stressed that. When you look at paragraph 119, the court basically says at the end of the paragraph that it will not accept it because if it would have the implication that it would be understood that individuals could be protected on that basis from the exercise of their own fundamental rights and freedoms. So we don't protect people against their own exercise of freedom of religion. So that's an anti-paternalism argument. Also, there have been studies done to show, basically empirical studies, that there are very different motives why women wear the full body veil. So it can be more a cultural, a spiritual thing. It can be a free choice. It can be imposed. So it's sometimes simplistic just to attribute one meaning to it. That's what it means. And So gender equality here dismissed, and it's interesting, I think the European Court evolved on that point. Because if you look at Dalap, the Dalap case, it wasn't a decision, but it's quite developed. It was about Switzerland, and the teacher was wearing the headscarf. The court there basically said that also the headscarf was basically a symbol also, which was hard to reconcile with equality of the sexes. And the court got quite a bit of criticism for that, saying it's not up to the European Court to cast such a negative, make such a negative judgment on one religion. And I think we can see it in SAS that the court is more cautious, doesn't advance that anymore. Then you could have another take on it. Let's assume we say, well, it is a valid argument. We ban basically the full body veil to protect women. You could still make then another argument to say, I still believe, well, the ban is not justified. Anyone got an idea on this one?
That such measure will forbid women to enter into the public space, and it will be more discriminatory for them, not adverse effects.
So I think the other argument is to say, as you say, adverse effects or counterproductive effects. So you liberate women by a ban, which will mean that they may not leave the house. I have a colleague who wrote an article that she brought examples of, I think it was actually a Quebec case, which she quoted, where women were excluded from a citizenship course because they were wearing the full body veil. So you have to say, well, or there's a Turkish case that's about the headscarf, Leyla Şahin versus Turkey. You exclude a student from the medical faculty because she wears, well, the veil. I'm not sure you will make great headway with gender equality with that. So in a way, but the judgment is always yours. So there might be different ideas. What I'm trying to show to you is that you can take different positions. You can either say, we reject gender equality because there are different motives why someone wears this type of clothing. We can't reduce it just to coercion. And if the person wants to exercise this freedom of choosing this type of dress, well, we don't want to be paternalistic. Or you could say we accept that this is a clothing which does reflect this idea women are, have to be hidden away, etc. But we may have doubts that the measure will be useful. Find other measures. Go and target the people who compel them, etc. Don't target necessarily the victims. So that was the argument on gender equality. There was another argument the court dismissed as well. The human dignity, what was the argument there about human dignity?
I think the government just invoked it, saying that it's, if you wear a veil, it's against human dignity because you protect certain. I don't know what the reason was, but the court said it's not that these women who wear a veil, they express contempt against others. So the court basically dismissed that argument.
I think there were two arguments, if I remember correctly. On the one hand, saying it's against the dignity of the women, and the other one saying it's against the dignity of the other people. So you're in the street and you see the woman and you say, well, this is. What do you say? Can someone make an argument that it's against women's dignity?
I don't know. I think it's very imposing your view on dignity.
But it's also a debate you find quite often when in philosophy and about what does dignity mean, where you have the one idea which says dignity is mainly about exercising your freedom. So again, we will not protect people against themselves. It's not about having a certain image, how you should behave. And another strand of human dignity basically saying, well, it's also, and you can partly link it back to Kant, who's this major philosopher on dignity. For example, he was very much against suicide, saying you don't have the right, to treat yourself as an object. That if you kill yourself, in a way, you treat yourself as an object which can be discarded of. Obviously, you can see the impact of religion as well. I mean, human dignity also had a religious interpretation. We are made as creatures, resembling God, and in a way, it's more an offense to God. But this approach that human dignity is also how you act, how you appear, that you would make the claim here by saying, well, it's against human dignity, though basically you become a faceless individual. No one sees you, you're not an individual, you're kind of packed away under this, we don't agree. Similar things you would see about prostitution. Begging, I heard that for begging. You have to protect the beggar's dignity. It's against human dignity to sit there and ask for money. It's degrading. Prostitution, no reasonable person would want to do that. And feminists are divided on prostitution. Some feminists will say, well, you really have to protect women against that practice. Others will say it can be a free choice. We should not go and impose here our vision. What is a decent job? And then you have also arguments that France, for example, prohibits, I think, or it criminalizes, it's the customers. But that legislation also has worse effects. So we're always I'm just trying to outline how, the reasoning can go in different ways. So here the court again adopts more this, I would say, approach. It's more about the individual's choice and freedom. And it's not us imposing, how you should present yourself.
I had a question with all of this development. How does one justify the government's, because let's say because of this argument of dignity. So if we take the argument of if you have a full body build, it's against human dignity. Therefore, we must protect women against this. Thing. Then how does one justify that it's the government's job to do that and not their own job or their own will to go and ask? Because then again, if they feel like it's against their dignity, it's their personal right that they should go and fight for it. How does one justify that it's the government's job to do it, to protect them against their own?
Probably the argument will often be made they are coerced, and so you have, a duty to protect fundamental rights also against interference from others.
Okay.
So I think it goes more that way. So they will rarely say protect people against themselves. I have seen that argument. Sometimes it will be said, well, no person, they are brainwashed more or less. That's, no person in their real mind, can walk around with voluntarily in a summer day, having disappeared, etc. That is a line of argument where there is a risk that you will say whatever we accept is normal because we're used to it, and we will not be very critical with our own practices, and we will look at others saying, So you create a dichotomy on the enlightened, progressive Western women and the others. That would be the criticism of it, who are an object of whatever and not really free, etc. But that's I have heard those arguments. So it's and maybe one just to illustrate these two interpretations of dignity. Has anyone heard of the dwarf throwing case? No, dwarf tossing. No. Okay, you have.
I think it was a French case in which, in the north of France, in nightclubs, they were throwing dwarfs as a game, and the Supreme Administrative Court in France forbids the activity. And there was an analogy with prostitution, and they said like dwarf can do whatever they want with their body, but the French Supreme Court said no, so now it's forbidden to throw dwarfs in nightclubs.
So there was someone, and he was a dwarf, and his job was, I think, also, when you have fairs, etc. So you paid him money, and you could toss him, I don't know, into a water container or something like that. And then it was argued that's against public order, because you cannot treat, there was the argument, a human like a projectile. He's not an object to be tossed around. And he he complained, saying, well, that's my job, I'm happy, I'm doing happy. Maybe didn't say I'm happy, but this is what I decide to do. So again, comes paternalism. Is it up to the state to say you should not be treated like an object? I protect you against, and it was considered as part of public order. You know, you could think of other things, maybe kind of sometimes laser games was debated in Germany. Can you have games where you go and, you know, kill each other? But just as different conceptions of human dignity here, the European Court clearly, I think, indicates that it will not accept human dignity as an argument, and also says that basically we have, it stresses the variability of the notions of virtuousness and decency that are applied to the uncovering of the human body. So here you could feel, you know, saying, well, you might have different traditions and customs, so let's not be too quick to leap to the conclusion and say this is against human dignity. So these two got discarded, and then there was this idea of living together, vivre ensemble, etc. Linked to the rights of others. How does this argument run? Why is it against the rights of others if someone wears a full body veil? What is this rights of others in a way? Who can make, or paraphrase the French position? You may agree or not agree, but before we, yeah.
That there should always be the possibility to interact with anyone in the public space.
So it's, I think they made it a bit, it was two strands of the argument. In a democratic society, we have certain, I would say, rules and practices, and one is that we interact with each other. It's normal to see other people's face, we can interact in public, and so it can be linked to their concept of democracy, or saying, well, I have also, in a way, a right that I meet other people and I can interact with them. What would be your take on this? The European Court accepted it. Here maybe we can make the link to the Human Rights Committee, which found things differently. If you're interested, I remember that the Revue trimestrielle des droits de l'homme, they published at the time an article written by two professors, and one in favor of vivre ensemble and the other against. And I find it always interesting when you have two very different points of view. Any ideas on vivre ensemble? How would you have decided on that point?
I think there's something that is, when you say this piece of cloth is somehow going to stop me from treating you as a human and being able to live together or having a discussion, like there's something that I reject in that premise of this idea of if you're at Carnival and wearing a mask so you look like a fairy princess, I don't know, we're not saying you're somehow someone who we can no longer interact with in the streets, you're no longer welcome on the public square. So this idea of this particular type of covering marks you as so much of an outsider that we can't live together, I don't love that argument.
You don't like it? Anyone? Other ideas on that?
Inside my point of view, my point of view is it's also justice-wise. It doesn't also make sense not to see someone who's veiled top down when the other person is not. So there's also a question of values, principles, and the territory where the person is, and of course it's imposing some human rights because the values are not the same, and then it's weird when you see someone who is viewed like this. You might ask a lot of questions, and it might pose some security issues later or whatever. But principally, justice-wise talking, I know in reality there's no justice, but I mean, it's not like we should all be the same, also development-wise, some kind of cultural equality or equity is also needed to have a better society.
So are you making the claim that, I don't know whether it's normative or sociological, to say if the customs are too too divergent, then that is a problem for social cohesion also, that people will find it extremely hard to come to terms with something like the burqa, which they are just absolutely not used to.
Yeah, about social cohesion, yeah, because it depends where the person is. Like if you're, yeah, like countries like France, Europe, etc. I mean, there are certain. I mean, there are some certain human rights values which are not based on like covering the whole body.
But then you have to, I think we have to be precise and try and identify these rights or values, because I mean, if I assume fundamental rights are more normative, it's not descriptive. I know if I go and ask people, general population, I knew in Switzerland that we voted on the full body veil ban, I knew it would be accepted. There was no law professor who would convince, the population that this is not something weird. And then came the gender equality argument. It was clear that that would be accepted. But normatively speaking, the argument, I feel this is strange. We have to ask, is that good enough? I would say.
I think also in the next case, they sort of connected it with like the rights to privacy. You, in a way, also have the rights not to interact with other people when you go into the streets. For example, also you could put on like some sunglasses or like a big hat in order not to interact with other people, and that's okay. But then when you put on a veil, it's supposed to be not okay.
So it was basically looking at what does it mean if I have a right? Have I got really, if I say I have a right to interact with you, so you would have a corresponding duty to interact with me. And can we really assume that this is the case? And if we take it seriously, what I would suggest, we ban smartphones in public. Who do you interact with on a tram or on a bus or on a train? No one. Everyone's on their phone. So if I have a right to interact with others, let's ban smartphones. COVID was interesting. So, but that's my point of view. You might well have a different point of view. I felt it was relatively convincing to say, well, do we have a right to interact with someone else or not? And to say, well, I'm not sure that this is that such a right. If we take it to a logical conclusion, I'm not sure such a right really can or is really recognized.
Well, it depends on if you know how to interact. The importance of knowing how to communicate can make a difference. But then
But there is first the question: do I want to communicate?
yeah, but this is a freedom. If I don't want, I don't want. Every person has a certain capabilities. It's also freedom. It's also freedom and dignity. It all depends on the laws and the values and the culture and the society we live in. But the case of smartphone is different. This is not. We cannot compare banning smartphones to. This is like it's development. It's encouraging. Maybe it's something good for the society in the future. But of course, it has some side effects or whatever. But then this is like religion. This is something is very sensitive, but it's also complex because some people do not understand the concept of God, but do not know the rule of the law, and then that's why it's very complex. So if these people do not understand, do not know the rule of law, then
But what do you mean by they don't know the rule of law? Or
how to be more civilized, because it's my point of view.
but isn't that already? I mean, you say there's a due.
Promote human rights and liberty, but these people maybe who are veiled, they have a different concept or maybe something different. I don't know. But that's why it's about that you have to be smart how to interact. What's your aim? What's your objective? It's about communication. But then if I don't want to interact, then it's also I'm free. Like it's also a free choice.
Yes, but isn't it I think we're mixing up different rationales. One rationale is to say, on the one hand, I have that when people are here, they adapt to local culture. That is an assimilationist argument, which sometimes courts make, but the freedom argument, and always we have to be careful with the othering. When we say the others, they have necessarily, values incompatible with us. But then if we say that it's about, I have a right to interact with you in public, and that's why you can't wear a full body veil, I don't think I can say, I can make that argument and then say, but anyway, everyone's free to interact. Then I think it's contradictory in itself, but I'm not...
But that's why the concept of the values in the local culture is, this is what plays a huge role in impact. And that's why we have...
No, but I think you have to each time identify what is the purpose I'm trying to make. You can have different objectives, but then you have to check, if I make claim A, I have the right to interact. Really, does that make sense or not? Maybe there's then another aim we will want to defend. But so just interesting to see the European Court accept it, the living together argument. It is a legitimate aim. And then comes the next stage, is basically about proportionality. Is it necessary in a democratic society? And there, the European Court by now comes the question of the margin of appreciation. If the state has a wide margin of appreciation, it means the state will win, and the European Court more or less, will repeat the arguments made by the state. If the margin of appreciation is narrow, there's a good chance that basically the applicant will win. What did the court do? Or did you find some hints about the standard of review? And justifications, you also have to give reason. You can't just say, well, I feel like giving a big margin of appreciation or not.
In Europe, or at the time of judgment anyway, there wasn't this kind of a uniform, general consensus on banning corporate sale, so there was nothing to really compare it to. And so then it was, France had a wide margin of appreciation, because there wasn't this general consensus between countries.
So one criteria is always this European consensus, and we will return to it. What I found in the judgment first, some passage I was thinking the court will probably now be relatively strict, but then the court changed a bit, because it was after living together. It's paragraph 122. The court says the court is therefore able to accept that the barrier raised against others by a veil concealing the face and so on. Also, when the court uses the formulation, the court is therefore able to accept, it means more or less I'm not 100% convinced. It's more like I'm already being a bit deferential. I can accept it, I can live with it. I will not challenge France and say you're living together arguments, I don't buy it. But then in the same paragraph, basically, the court says, that being said, in view of the flexibility of the notion of living together and the resulting risk of abuse, the court must engage in a careful examination of the necessity of the impugned limitation. So I read this and thinking, they will do strict review, because they say, here we have a concept which is flexible, which is a bit vague and so on, What does it mean living together? Other scholars have asked. Would it mean begging has to be banned? Anything which is a bit not mainstream. So here the court seemed to flag strict review. But then when we look at the analysis later on, the court, rather paragraph 129, then referred to the principle of subsidiarity and saying, well, here we have a matter of general policy. There may be reasonably differing views, and the domestic policymakers, they have direct democratic legitimacy. So a wide margin of appreciation is given, and they also refer, it's paragraph 129, to the consensus and common values, etc. And then basically the court says there is no uniform conception of the significance of religion in society, so wide margin of appreciation. That's paragraph 131. So from 129 to 131 in favor of a wide margin of appreciation. And paragraph 154, the court also says it will exercise a degree of restraint because it is a matter, it's on matters of general policy struck by means of a democratic process where we may have different views. And comes back 156, the European consensus. So if we take the different arguments, and we have a dissenting opinion on that point, not just on is living together a good argument or not. There, the court often uses European consensus and then get challenged for how it was used. The dissenting justices basically say, well, here it was used in a way. You could have argued, if you look at the specific problem of full body veil, France is, at the time, was the only state banning the full body veil. So there is a consensus against it. For example, the court did so on a begging case against Switzerland, saying Switzerland is among the very few states which have a blanket ban on begging and links it to criminal sanction. And therefore, there is a European consensus that you could ban some forms of begging, or you could have, it's not a criminal offense, the general ban, so strict review. So it would have been possible for the court to do that, say there is a consensus actually against this ban, but it didn't do so, it framed it more broadly. So it's a question of framing as well. Do I frame it as it's about the full body veil or about the general relationship state-church? And here the court framed it more broadly. So scholars sometimes criticize the court for saying it's a bit of strategic use, that it seems to rather decide what it wants to reach and then it will say, well, that's what the consensus said. Then there was also the question which the court argues that it's a general policy, a question of general policy which the democratic decision maker basically can decide. The opinions may generally differ. What do you think of that argument? Can anyone think of a counter argument to that one? What does it mean it's a question of general policy? Is that a... I'm not sure, am I the only one who finds it's not very clear? Because, any law, you could say when an interference is based on a law enacted by Parliament, you can often say it's a question of general policy. So why here should it... Well, there is one strand of case law of the court which I find more convincing. It used it, for example, animal defenders, etc., where it will look at the quality of the lawmaking process. Have there been a lot of consultations? Has the impact, on different groups been taken into account? There I have a bit more sympathy for the argument. Here I feel a bit, what does it mean? It's a question of general policy. How do we distinguish it from other laws? Why is it if something is controversial that you say it's a question of general policy? And it may then be, it depends how you view fundamental rights, how much weight do you give to the majoritarian, conception, or whether you say it's mainly about protecting minorities, and then you would say, well, maybe democratic processes are not so good, even if it's about general policies to protect minorities, which are perceived as outgroups, so like Muslim women. The court did say at some point that we have to be careful that, there could be stereotypes linked to the full body veil. So I think what I felt the most, it's paragraph 149, the court basically says in this connection the court is very concerned by the indications of some third-party interveners to the effect that certain Islamophobic remarks marked the debate which preceded the adoption of the law, and the states should generally be careful that it doesn't, when they legislate on such issues, that you don't reinforce stereotypes, etc. How concretely you do that? And one last argument, and you tell me what you think about it, paragraph 151. The court basically says it's true that some significance to the argument that Muslim women are more concerned by that ban, but it says it nevertheless, so the court finds it to be of some significance that the ban is not expressly based on the religious connotation of the clothing in question, but solely on the fact that it conceals the face. So what does that tell us? It says it's not directly discriminatory. It doesn't say the law itself, we ban the full body veil for Muslim women. It's couched in more general terms. Does the Human Rights Committee buy that argument? What did the Human Rights Committee, you've read it as well, what did it decide? First difference, it did not approve the living together. It said the limitation grounds in the covenant have to be interpreted restrictively. When we talk about limiting rights because of the requirement of rights of others, well, there is no right to be to interact in public. So the Human Rights Committee already had very strong doubts about the legitimate aim, but then also looked at it under proportionality and under discrimination. What did the Human Rights Committee decide on discrimination, basically? It's not an extremely elaborate on the reasoning, but it does come up with something. You're running out of steam? It says it's an intersectional discrimination, right? It's indirect discrimination and, oops, I have to see where it's paragraph 1.17, the court concludes it's an intersectional discrimination based on gender and religion. So the idea, does everyone know what intersectionality is? The idea that you can be discriminated based on several grounds, and they are not isolated, they interact, they might create their own stereotypes. So a stereotype often with full body veil will be extremism, sometimes used on leaflets saying, see, it's political extremism, or female women are being oppressed. So we have a very different reasoning here. The Human Rights Committee basically says there is an indirect discrimination, there's a disproportionate impact on Muslim women, and it looked more closely at the law and said, well, how did it, the factors it took into account, it was 8.17 paragraph, if you. It said, well, when we look at the debates in Parliament, it was quite obvious they were targeting the Muslim veil. So that was one indication to say it's a discrimination, and the other one was to say when we look at the law, there's so many exceptions built in there, which basically at the end leaves nothing but the full body veil. So there's exceptions for sport, so there's exception for carnival, and so on. So they're saying, well, in fact, well, you were relatively smart how you drafted the law, but the impact is on Muslim women. Where I felt, so again, there the European Court is quite different by saying we give some weight to this fact that the law does not target explicitly, Muslim women, but is couched in more general terms. So comparing maybe the two decisions, I would see differences. First of all, we can see differences about the legitimate aim. The Human Rights Committee interpreting narrowly the grounds of limitation and saying living together is not part of protecting the rights of others. The European Court here being less restrictive, interpreting the rights of others more broadly. Then I would say a big difference is the standard of review, that the European Court sends the signal of, okay, we will do strict review, but then does the opposite, wide margin of appreciation. It's about no European consensus and the question of general policy, etc. I think the main point is also knowing that France would have probably not implemented the judgment, but that's... And then comes on the argument on gender equality. I think European Court does not accept gender equality as a ground for limiting the right, but it does not find that the full body veil is a discrimination, whereas the Human Rights Committee says it's a form of discrimination, indirect discrimination based on gender and religion. The court does look at the discrimination argument at the very end, under Article 14. And Article 14, often the court does not examine it very thoroughly. It will often say, well, we've already said it's not a violation of another right, or it is a violation of another right. We don't have to look at discrimination again, or two. So here it's relatively cursory. So you have here, and it's, by the way, interesting that the Human Rights Committee does not use the margin of appreciation doctrine. That's something quite different to the European